Okay, it looks like we're going live. Just for everybody out there, we've got about a 20-second lag time. So I'm just making sure I'm actually seeing it going before we get underway. Okay. All right. And I'm seeing us broadcasting. So welcome, everybody. Thank you for being here. This is the first time doing the webinar series via YouTube. So if there are glitches, please forgive this. But go ahead, Shalene, take it away.
Hello, everybody. I just wanted to welcome this year's lineup for webinars. Our speaker today is Jeffrey Marsocci. He's going to be speaking on Medicaid pre-planning, and I'll let you go ahead and take it away from there.
Okay.
Hi, this is Jeff Marsocci, the Plain English Attorney, and this is a webinar specifically for the estate planning source, and it's on Medicaid pre-planning. Now, Medicaid pre-planning is another level up, really, from estate planning. If you really think about it, as professionals, we are committed to helping our clients plan ahead the right way, and avoiding probate for their estate is a big part of that. And so we can put their estate wishes into a revocable living trust, which is going to get their assets to where they want it to go after they pass on. It's going to help them provide a mechanism for someone else to take control if they can't, and take care of them. And it's a way to keep all of this stuff out of the court system and away from a whole bunch of legal paperwork. Really, the way I'm looking at it and describing it to my clients is revocable living trust planning is the difference between using a will and having the government estate plan, or having a revocable living trust, which is the private estate plan. So if you can avoid probate, great. But now what about qualifying for Medicaid if you need long-term care? So seniors 65 and up are qualified to have Medicaid pay for long-term care if they meet all of the criteria, which includes what assets they're allowed to have and still qualify for Medicaid. And so it becomes this whole big hodgepodge of rules. What can you move around at the last minute, and what can get spent and what can go here? Is there any gifting? All of that stuff is last minute planning. What if there's an in-between? Well, there is. And we're calling that Medicaid pre-planning. This is where you can set up what we call the Medicaid Toolbox as a way to position certain assets, but not others, but have that whole mechanism in place just in case it becomes necessary to start making some really good strategic moves in order to qualify for Medicaid down the road. Now, the big stumbling block is this 5-year look-back period. So at its simplest, if you take assets, move them into these irrevocable Medicaid qualified trusts, 5 years and 1 month later, go ahead and apply for Medicaid. Medicaid can't go back and say, well, 5 years and 2 months ago, you moved all of this money, and so we're going to disqualify you. No, they can't. That's what the rules state. The big thing with these trusts is that you're giving up a certain amount, if not total control. So what I'm going to do is run through, here's what we typically have for estate planning documents with a revocable living trust. Talk then about the Medicaid planning trust that I typically use in my practice as a certified Medicaid planner for both my North Carolina clients and when consulting outside the state, and how they work together and what kind of assets are we talking about and what kind of options do we have to, again, pre-plan. All right, so with a revocable living trust, there are documents that typically come along with that. So you've got your revocable living trust. This is where all of the estate wishes are put in. You've got your trustees who are going to take over after you, the successor trustees. And the assets get funded into the trust to help avoid probate, to avoid living probate. And you also have that come along with that revocable living trust. You've got the financial power of attorney. typically the durable general power of attorney. So this is authority for someone to take control of assets outside of the trust in the event of an emergency, or just straight out they have the authority to begin with. So this is the person who's taking on applying for Medicaid, moving assets into the trust if they are outside the trust, signing tax returns and all that stuff. They're basically legally and financially standing in for you as an individual. You also have then the healthcare power of attorney. So the healthcare power of attorney is the person who's standing in when you can't make these medical decisions for yourself. So they're the people, if you're unconscious, you're not in your right mind, you don't have the capacity to make these decisions yourself, your healthcare power of attorney agent is the one who's going to be able to stand in and make these decisions on your behalf for you. We also have a living will, or in North Carolina, we call it a declaration of a desire for a natural death. So this just kind of takes care of those final end of life wishes regarding life support and artificial nutrition and hydration. We also have an organ donation form, which talks more about intentions regarding organ donation. In North Carolina, we have this little heart that you can put on your license that says, yes, you want to be an organ donor, but it doesn't give you any more specificity than that. And in fact, not having the little heart on your license doesn't mean, no, I don't want to. It simply means you haven't said anything. So this important document will lay out what are your wishes regarding organ donation. And there's also a nomination of conservator. And the way I really look at this document overall, it's the way to keep stuff out of a conservator court, to keep it out of a living probate situation. So you're naming your conservators. Now, not all states have it this way, but North Carolina does, and I think it's a really good thing. You can have a conservator of the person, and you can have a conservator of the estate. So the way I really typically line all of this stuff up, when I'm talking with my clients, is like, okay, we've got really 4 big questions, but 2 of them. The first one is, who do you trust to make financial decisions for you if you can't? We want 1 person. If they can't, there's the next. And then if they can't, we have a 3rd just in case person. So that gives me a list of at least 3 people. I know other attorneys or professionals may look at it differently. They may go item by item, but that one list, that's who I put in as successor trustees. That's who I put in as the financial power of attorney. That's who is the conservator of the estate. Second question is, who do you trust to make healthcare decisions for you if you can't? And come up with a list of 3 people. And it could be completely different. It could be some of the same. It could be exactly the same. But that list of 3 people is who ends up as your healthcare power of attorney agent and your conservator of the person. So those, the way I kind of look at it, it lines up nicely. Now we are coming back to that. So those are the estate planning documents. Now that's with the revocable trust being the centerpiece of the estate plan. This can and will change if we move to actually using the Medicaid planning documents. But if we're setting up a Medicaid planning trust, well, Medicaid planning trusts, what are those kind of additional documents that we have to have in place for the Medicaid pre-planning? Now, the core document for this is what I call the irrevocable family trust. So now we're really getting into the core of this. An irrevocable family trust is one where you have your trustees named, you're putting assets into this irrevocable family trust, and you're walking away from it. You're not retaining any rights here. So it's as if you gave those assets away. So this is the point when I'm describing it that a lot of my clients are going, whoa, wait a minute. I don't want to give up control of my stuff because I'm not sick. I don't have any reason to. Well, okay, that's for the full-blown Medicaid planning that we may have to do down the road. And then I get back, well, I'm never going to want to give up that control. Don't ever say ever. Don't ever say never. And the reason for that is when you're faced with 10, 12,000 or more per month for nursing home care and skilled nursing care, suddenly the family dynamic and thoughts on this starts to change a little bit, and that's fine, but that's why we're putting these documents in place now. That irrevocable family trust will list out those trustees, and it kind of has two phases. The first phase is while the client is alive, or if it's a couple, as long as one of them are alive. So the assets go into that irrevocable family trust, and the way we have it set up, and this is why that question of who do you trust to handle financial things comes right back. You really, really, really have to trust them, because essentially they are also the beneficiary. So this isn't something where you can really have a financial institution or a corporate trustee. They won't do it because technically they're the beneficiaries and they just don't want to get involved with anything like that. So typically it's the trustworthy children who end up being the trustees. Well, okay, that money's going in there. How do we get this to mom or dad? They have to take the money out. The trustee, they take it out. They put it into their personal account because they are the beneficiary under this. And then they can turn around and pay for things for mom or dad. So they can filter that money in and out. But in that first phase, that irrevocable family trust is locked up, and the clients aren't even beneficiaries anymore. So that's how powerful this is, but that's exactly how powerful it needs to be for Medicaid to be able to look through the trust and go, well, okay, they're not beneficiaries. They don't have any interest in this anymore. Once that 5 years has passed, it's done. Okay. What's the second phase? Well, the second phase is after that individual or that couple, once they're both deceased, now it kind of cuts off and we list the beneficiaries that they want as part of their estate planning wishes. So that's how that gets incorporated into the irrevocable family trust. So now all of the terms that you typically will look for in the revocable trust, it's who's getting what are the different contingencies, do we have any kind of age limits, what kind of trust structure are we setting for younger beneficiaries or beneficiaries who have other issues. All of that can get incorporated into that irrevocable family trust. Thing is, you're setting it up, it's irrevocable. So generally speaking, with this irrevocable trust, you really aren't going to fund it all that much unless you are absolutely set on those beneficiaries. So you really, in that sense, should be treating it just the same way you would an irrevocable life insurance trust, because you're putting assets in and then you're walking away. So that is the main one. There's another big trust that we kind of call part of the two trust solution. And in some of my materials and some of my videos, you may check those out and see, I talk about, quote, the two trust solution, even though it's really more than that. It's four main types of trust for Medicaid planning and Medicaid pre planning. It's the irrevocable property trust. Right. So now the irrevocable property trust it's an intentionally defective grantor trust. And the way it's designed is that it is an irrevocable transfer for what you put into it, but you're retaining a couple of rights. The rights that we want to retain are, one, all the income generated goes to the clients. And the second thing, it's the right to live on real estate and property. All right, so why do we have them retain those rights and also retain the responsibility for the upkeep, the taxes, and all that other stuff? It's because we're straddling really two different sets of rules. One, we want to make sure that 5 years after those assets go in, they are off the table for Medicaid. So looking at those retained rights, the right to the income and the right to live on the property, Medicaid's rules say, no, that's not enough, that we can say this is your property and you have to have it as part of your spend down. So that's the big one. The other one is, well, okay, having the right to the income and the right to live on the property and a couple of other adjustments, that's actually enough that it's included as part of your taxable estate. Well, why would you want it to be included as part of your taxable estate? Well, because if it's included as part of your taxable estate, it gets that capital gains stepped up cost basis upon death. So if mom and dad are taking the house that they've purchased 30, 40 years ago, and they're putting it into that irrevocable trust to protect it from Medicaid, you also want to be able to still get that capital gain step up, because if they bought it for $90,000 and now suddenly when they pass on it's worth $800,000, you don't want to have those capital gains on that 820,000, whatever it is. You don't want those capital gains taxes imposed. If there's a way around it, this is the way around it. So those are the two main ones: irrevocable property trust and the irrevocable family trust. The property one for real estate, and the family trust for the financial assets that you want to preserve and start the 5-year clock on. All right, so what are the two other big Medicaid planning trusts? The first one, only certain states are going to need this, and it's just because of the way the rules are. Some states have an income cap, and it's usually something ridiculous, like, well, if you have more than $3,000 a month in income, well, you're not going to qualify for Medicaid. Well, when you're talking about costs of $10,000 to $12,000 per month, that's just ridiculous. And it was ridiculous when they had these rules put into play, and that's why there was a big lawsuit, and that's why we ended up with the Miller case. And the kind of way they settled and came to a conclusion and a settlement was, if the assets went into an irrevocable special needs trust, this Miller trust, the income would be directed to go into that trust, and it's not going to be counted as income, but that money each month has to go out to the nursing home because it's treated as an asset inside that trust. So it was a little bit of sleight of hand. It was legal maneuvering, but okay, the money comes in, it goes out each month. It's a way to get around that rule. Often, and you can talk with attorneys who do Medicaid planning in other states, I think they can apply to a court and try to get this trust set up judicially. And well, look, if you already have it in place, fine. North Carolina doesn't have that rule, but look, I wouldn't put anything past our state legislature, the General Assembly. I have that in place just in case, because I don't want to end up with, okay, they changed the rules. I have a client that's already incompetent to change their documents. They're already in a facility. It's like, well, okay, sorry, you're getting kicked off of Medicaid. Go apply to a court. No, we've already got the trust in place. So it's set up just for that purpose. And then the fourth trust, it's an irrevocable funeral trust. Okay, and this is really around one rule that Medicaid has when you're applying. If you're doing that spend down, you are allowed to take up to $10,000 and move it into an irrevocable funeral trust. And it's used for those purposes, for funerals and burial plots and whatever. And some states have very specific things, and you can do this or not do this. But the main point is, if you're in those kind of last stages of a spend down, all right, you need to do something. You've got this extra money. Okay, we can put up to $10,000 in there to make sure that funeral and other expenses are done. Now, this is a very important distinction. You cannot just put $10,000 in there, have a $3,000 funeral, and say, oh, well, the family's going to get $7,000 back. No. Whatever is left over in that trust goes back to reimburse Medicaid. So this is a strategic thing when you get to that point. But the point is, you've got the shell there. You've got that trust. It's there. It's ready to do what it needs to do. You don't fund it ahead of time. It's there for the last minute spending. All right. So those are the four big trusts. Again, let me tick those off. 1, the irrevocable family trust. 2, the irrevocable property trust. 3, the special needs Miller Trust. And for that, it's one per person. And same thing, one per person, the irrevocable funeral trust. So that's the set of the Medicaid planning documents. There's also something else that I put in, and I believe the estate planning source has this. If not, I'll make sure to give it to them. It's an affidavit of an intent to return home. Well, what is that for? It's so that when your clients are signing up and pre-planning, or even if it's at the stage where you need to do the actual planning, you're signing this affidavit, if you're competent and capable to, saying no matter what, I have the intention to return home. And I've got enough time here. I'm just going to tell the quick story because this was someone called me way late in the game. And between me and a colleague, and usually more the colleague, we were able to yell and scream at Medicaid. What they had done was, it was a woman and her niece. And the niece was going to inherit the house because, the aunt didn't have any children. She was the one who stood to inherit. She's helping her aunt out. And she did the one thing you should never, ever, 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 ever do. Oh, let me go down to the Medicaid office and ask questions and get help. They'll help us out. They'll help you spend every single last dime, which is exactly what they did. So rather than actually fixing up the house and spending the money there, they gave them a chart of how to spend all the money on care first. And then they applied for Medicaid, even though the house, in the niece's words, it was, quote, basically falling apart. Okay, what happened? Well, after 2 months of Medicaid, the caseworker calls the niece and goes, yeah, how's she doing? Just acting all concerned. How's your aunt? Is she doing okay? Oh, well, she has good days and bad days. Oh, do you think she's ever going to go home again? Oh, no, I don't think she's ever going to go home. Oh, okay. 3 days later, they get the letter. Medicaid is cut off until you sell the house because you have to have the intent to return home. Oh my God, that caseworker intentionally went in to try to get them to say that so that they could cut off the Medicaid and make them sell the house. Well, okay. It's the subjective intent of the person. Just because the niece was the representative, it shouldn't have meant anything, and that's how we got out of it. But so that there isn't any question in this pre-planning, it's, look, if I have the option to return home, I'm always going to want to return home. We always have that in place just in case. All right, so those are those Medicaid planning documents. Now we're getting really to the question of how and what do you fund for pre-planning? Okay. If you've already got your revocable living trust set up and everything's there to avoid probate, and you want to integrate these Medicaid planning documents as part of pre-planning, what are you comfortable starting the 5-year clock on? For a lot of my clients' cases, they're ready to move the real estate. They're okay moving the family house, the vacation house, unless they've got like multiple real estate that's actually rental property. That's another issue, but it's their personal residences and real estate and lots that they're willing to put into the irrevocable property trust to start the 5-year clock, and it secures at least the real estate. Here's one important part. If you've got a mortgage on that property, the mortgage company can exercise the due on sale clause because it's actually being transferred into an entity that's not 100% still in control by the people they made the mortgage to. Keep that in mind. Have we done this with property? Sometimes our clients, and this actually happened, clients told us, oh no, there's absolutely no mortgage. We moved everything in, and then we found out later that about 6 months before they came to us, they took out a huge mortgage. Okay, not our fault. Didn't see any of the liens or any of that other stuff. They gave us the deeds and we handled it. All right, but just realize that moving that into that irrevocable trust could cause some property issues if it's not free and clear. What about financial assets? A lot of the times when my clients are doing this pre-planning, they don't want to give up control of their liquid assets. Now, some exceptions to that might be, all right, look, if there's a family-run business that's worth a lot of money and they're going to go ahead and put their interests in because they know that the corporate structure is taking care of the family business. They already have the kids or other relatives running everything appropriately. It's not something they're going to liquidate ever. Okay, they'll move that and secure that. Here's the important thing. This will not get a capital gains stepped up basis when they pass on that stock. So sometimes they'll do that. But by and large, most of my clients that are doing the pre-planning, they're only doing the real estate into the irrevocable property trust. But for a lot of clients, that's a significant, if not a majority, of their wealth anyway. It's in the real estate and they're willing to put that in. Well, okay, how do you deal with that real estate? I'm only going to cover this very, very briefly because we could really go on for a long, long time on this. The real estate is in the irrevocable property trust. The clients retain the right to live on the property. They keep the responsibility for all the taxes and insurance and everything to help upkeep it. But if they want to sell the property, can they? Well, technically, no, they can't sell the property, but the trustee can. So again, usually it's one of the kids. Can they sell the property? Yeah. Where does the money go? Back into the irrevocable property trust. If they do it because they want to purchase another property, purchase another property. And this is a feature that I'd put into the documents. If there's an excess of money that's not being reinvested in real estate, well, then the trustee can just take that money and shift it over to the irrevocable family trust so it can be invested in other things and not have to get paid out as income if there is income that's going to be generated from it. Something just to look at on a case-by-case basis. Sometimes it makes sense to keep it in there, sometimes it doesn't. Does the irrevocable property trust need its own taxpayer ID number? Not if you're just going to move the real estate in there and it's not producing any income. There's no reason not to, just keep that quote listed under the Social Security number of the clients because there aren't going to be any taxes. If you're moving any assets into the irrevocable family trust, then you do need a taxpayer ID number, because at that point the assets will have dividends or interest, and it is most definitely not on the client's Social Security number. The trustee needs to get a separate taxpayer ID number, and they need to file a 1041 tax return each year. So again, this is why most of my clients, when they're doing just the pre-planning, it's moving that one of those or a couple of those major assets in the form of real estate into that irrevocable property trust. So that's how that works for the pre-planning. All right, so what are some other items that you really have to consider when you're looking at this? If, again, especially if it's a client that you're already doing a revocable living trust for, it's a whole other ball game when they get to the point where they're going to have some needs to potentially get Medicaid. You can't have assets in that revocable trust because they get counted the same as cash. That's a Medicaid rule. There are some creative ways we can work and use that. But if you're keeping, say, a piece of real estate, oh, it's their family home, it's their primary residence, that's exempt, right? No. If it's held inside a revocable living trust, then Medicaid considers it as if that full value were just cash in the bank. That's the rule. So it needs to get shifted and transferred out. Oh, well, we've got the brokerage account in here because we wanted to avoid probate. Well, it still counts. So it's not protected for that 5-year look back. So that's just a couple of the important rules. So what are some advice, practical advice going forward? Look, if you should be pushing your annual meetings with your clients, and for some financial advisors, they even want to meet with their clients twice a year. If you're going to do this pre-planning, you definitely want to make sure that you're getting together, even if it's just for a brief meeting, once a year, to make sure that the situation isn't changing and evolving. Because at some point, there's statistically, if it's a couple, it's about a 85% chance that at least one of them is going to need long-term care. And if you start seeing the warning signs, that's when it may be time to say, all right, we pre-planned, we've got the toolbox set up, we've got the documents ready. It's time to start looking at moving some assets into some of these vehicles in order to help preserve them from a Medicaid spend down the road. So once a year, you at least want to take a look at that. The other thing that I just suggest as a practical matter, make sure you've got somewhere in your engagement agreement, and I'm happy to share what I have as an engagement agreement. If you're doing this planning, that they agree that they are going to contact you before they do anything. They agree that they're not going to talk with any government agencies without talking to you first, so that you could say, whoa, 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 hang on a minute. Let's look at this in a coordinated fashion. We've had several cases in the past where we did all the planning and it's like, okay, just come to us. And we kept checking in every year. It's, oh yeah, it's fine. Oh yeah, dad's going into the nursing home. He's already there. Well, I'm calling you because our Medicaid application got rejected. What did you do wrong? Well, we didn't do the application. Okay, it became this whole big thing that we had to spend a lot of time on to undo. And the last thing you want is for your clients to be able to come out and say, yeah, you are responsible for the actions we took because we had these vehicles. So yeah, we do have some of that protective language in an engagement agreement. You want to make sure if you're doing the pre-planning, this is something that can really benefit your clients and their families down the road. But you also want to make sure that they're at least coming back to you before they take any action. And at that point, if you're not the person who understands the Medicaid planning, you can get in touch with someone like me, another certified Medicaid planner, and walk through this whole thing and make sure that you've got the right plan for your clients so that it's not just a hodgepodge. And believe me, I've got several videos out. In fact, a fairly recent one on 10 myths of Medicaid planning that are out there, and just the falsehoods and the false information and people thinking it's simpler than it is. But look, the pre-planning is easy. You get the stuff set up, you get those Medicaid trusts set up, you move the real estate, you start the 5-year clock on that. Okay, good. We've set things up the right way to at least preserve those assets. And now your clients, maybe they'll never need them. Maybe they'll never need to do this. And, knock on wood, that's what you want. But it's better to have these trusts in place and not need it than to have needed these trusts and now it's too late to do anything about it. All right, so that's the presentation part. We're going to switch over to question and answer now. Okay, well, thank you everybody for attending. This is now time for any questions that you may have. Go ahead and put it into the chat. So I'm saying that, and I know that we've got about a 20-second delay between me actually having this get to you and the questions popping up into the comment section and, well, the chat. So please go ahead and put any questions that you've got into the chat, and we'll move from there. All right, so just as a comment, I know that the estate planning source has all of these documents I talked about. Again, maybe not the affidavit, but again, I'm happy to share that. And I'm also happy to share the engagement agreement that we do for Medicaid planning, just so you can kind of get the language in there, including the big disclaimers that they're not going to end up talking to the government agency without getting to you first. So yeah, please go ahead and put any questions that you have into the chat. Okay, we've got Amy June. Is there a requirement to fund these planning trusts when set up like there is with the revocable living trust? And what do you fund if you want to wait until it's needed? Well, no, there isn't a requirement to put anything into these trusts. You can have it set up, you can have them completely empty, but the big goal for a lot of my clients is that they are looking to have the real estate start the 5-year clock. So it's deeding that real estate into the irrevocable property trust that becomes the key thing. even if everything else, they want to keep control of the liquid assets until they spend the very last dime. Okay, at least the real estate is being preserved, and it's being preserved in a way that the kids or the family's still going to get the stepped up cost basis when they pass on. Very good question. All right. Go ahead with any other questions. Please go ahead and put it into the chat. Okay. I'm not seeing any questions, but we're going to hang out for just a minute or two. I'm going to bring Shalene back in, and I'll keep an eye on the questions. Okay. So welcome back, Shalene. Okay. Okay. All right. So any other questions out there? Please, again, go ahead and put it into the chat. All right, I am not seeing any, but we'll hang on for one more minute. The other thing is, please comment or let Shalene know directly if you prefer or you like this format for doing it. I know that there were some struggles last year with some of the technical things, and this is a new way of doing it, but let us know if this works for you. Just having a carrier like YouTube as the way to get it out there might just be an easier thing. Now, all right, we do have another question. How do you use the Irrevocable Special Needs Trust? Again, the Irrevocable Special Needs Miller Trust is just a way under the Miller case to kind of convert it from income that could put you over an income cap in a state. If it goes into this special type of trust, this Miller Trust, and then pays out to the nursing home, it doesn't violate that income cap rule. And the example that I gave in the video, and I usually give this, okay, what if the cap is at $3,000, but between a pension and Social Security and an annuity that you turned on, your income is $3,100 for the rest of your life. All right, that means that you're not, quote, eligible for Medicaid, even though the nursing home bill is $10,000 a month. Well, okay. This actually ended up being more of like an equal protection clause, constitutional fight against the way Medicaid was set up. Okay, it's all right if the income goes into the trust and comes out, and it was a way to avert like Medicaid being thrown out completely for this one thing. It's there to receive the income, send it right back out to the nursing home, and it just becomes a wash. Okay. Okay. Lonnie commented that he likes the way this setup was done. He actually was able to see it kind of through, even though at some point I think it got frozen on his end. Any other questions or comments? All right. Anything to close with, Shalene?
I just want to thank everybody for joining and look forward to seeing us more throughout the year.
All right. Well, thank you, everybody, and have a great day.